Hello everybody, this is David Campbell from Hassle-Free Cashflow Investing, and my special guest today is attorney Ian Ghrist.
Hi, how are y'all?
So Ian is a fantastic foreclosure attorney who I've worked with in the past, and I wanted to get an opportunity to ask Ian some of the most frequently asked questions that my clients ask when they're considering investing in mortgage notes, or they've got a mortgage note already that may have some payment troubles and they want to understand what the foreclosure process is. And as Ian will explain to us in the course of this video, that the foreclosure laws are very state specific. And so Ian is a licensed attorney in the state of Texas, and so what we're talking about today is unique to the Texas foreclosure process. And some of these concepts may apply generically to other states, but as we always say at the beginning of our videos, this is, although Ian is an attorney, he's not your attorney. So make sure that you don't use this as legal advice or investment advice or tax advice. Always consult your own professional advisors before taking action on any of the information that you hear in this video today, which is very educational and broad in nature. Ian is available potentially to represent you as a client, so if you are interested in what you hear today and you're looking for some specific advice, Ian, what's the best way for people to get a hold of you?
You can go to my website at gristlaw.com, just www.ghristlaw.com, and you can read my blog on there about foreclosures and other real estate related topics, and you can also get in touch. There's a contact form that you can fill out, phone number, fax, it's all on the website.
Awesome. So Ian, I always say begin with the end in mind. And so when someone's considering investing in a mortgage note, the two possible outcomes are they're going to be paid or they're not going to be paid. The I'm going to get paid is pretty easy for people to understand, but let's talk today generically about a person who's investing in a mortgage note or they want to be a private lender, and that aspect of, although it's an unlikely outcome, it's an important part for our clients to understand what happens when a borrower does not pay on a real estate secured note.
Well, if you don't do anything, then probably nothing will happen. Hopefully you're still sending out the monthly statements to the borrowers, and the borrowers can see how much debt they're accumulating, because the arrearage is going to keep growing the longer they don't pay. But eventually you're going to need to accelerate the note and then foreclose on the note if you want to force the issue with the borrowers. And typically that's something that you have to do, because if you don't, the arrearage is going to get so large that the borrowers will never be able to pay it off.
Mm-hmm. So in the spirit of no investor left behind, let's cover some of those vocabulary words that you use, some jargon, like accelerate the note means that even though the borrower has been making payments to you on a large balance, suddenly because of their non-payment, their note triggers a default where that's accelerated and they have to pay you the whole amount due, right? The whole unpaid balance?
That's correct. With mortgages, you have a promissory note that is generally going to be payable in installments, especially on owner-financed housing, because there's Dodd-Frank restrictions on balloon payments and things like that. So most of those notes are going to be installment notes that are payable in monthly installments. And each installment that comes due is treated separately from a legal standpoint. Like, for example, the statute of limitations on when you could file suit to collect on your debt arises at the end of each installment. Traditionally, in Texas, there's actually a statute that prevents the statute of limitations from running on each installment until the final installment that comes due. Mm-hmm. So that would be at the time that the note matures on its own under the terms of the note, or the time that you accelerate the note due to a default. And what the acceleration is giving notice to the borrowers that due to the default on the payments on the note, the creditor is going to accelerate the remaining payments that are due on the note and cause those payments to become due immediately. and to immediately mature the note rather than waiting until the note's natural maturity date.
So this is exciting. I mean, you clearly know your subject matter very well, and what's great is that I can imagine there's some borrowers at home whose eyes are already saying, I have no idea what Ian is saying, which means you really need to hire an attorney like Ian to help you through the process. Because as a hassle-free cash flow investor, we want the process to be very simple. And it is simple when you're working with a team, right? So the point of this video isn't for people to know everything there is to know about the foreclosure process, but to get a high enough level of awareness of the process that they can feel good about making an investment decision on the front end, because there's a possibility that they may have to go through a foreclosure or collection process on the back end. And when they do go through that process, this video becomes a lot more relevant, and they can check back in some of the vocabulary that they're learning in this video to understand what they're going through, right? Because I think the simpler we can make the process for our clients, the more likely it is they'll be successful. And the simpler we can make the process for clients, the more comfort they're going to have through the foreclosure process. So going back even in like the big picture, foreclosure is the magic word for getting the collateral for the promissory note. Because as you said earlier, there's in a real estate transaction or a seller financed transaction, there's the promise to pay, and then there's the security instrument, which is the deed of trust. And the foreclosure process is giving the lender the right to exercise their foreclosure rights and getting that lien and converting that lien into possession of the property through a foreclosure process. Maybe you could talk about big picture in that foreclosure process. What's the difference between, say, a judicial foreclosure and a non-judicial foreclosure, and why a non-judicial foreclosure in the state of Texas is superior than a judicial foreclosure in Texas, or a judicial foreclosure in a state other than Texas?
Sure. Not every state allows for non-judicial foreclosure. Texas does, and most liens secured by real property in Texas can be foreclosed non-judicially, which means that you can foreclose on the lien without filing a lawsuit and getting a court involved. Obviously, that's much, much faster and much, much easier, because when you have to go to court, if you are seeking a judicial foreclosure, then you would be filing a new lawsuit in probably a district court in the county that you're located in, and that case would be set for trial after a 9-month discovery period, sometime from 12 to 24 months from the day that you filed the suit. Now, obviously, by that time, if the debtor hasn't been paying, the arrearage is going to be tremendous. So in Texas, the notes that are purchase money notes can be foreclosed non-judicially. Purchase money means that the loan was extended for the specific purpose of the purchase of the property, and that includes properties that are homesteaded, that are going to be used as the principal residence of the borrower. Those notes can still be foreclosed non-judicially through a trustee's sale. So that when you talk about foreclosures, a foreclosure is actually an auction. It's a public auction that occurs on the courthouse steps of the courthouse for the county that the real property is located in. And a lot of times people don't understand that, because most of the time when a foreclosure happens, the bank takes the property back. Or in the case of seller finance, the original owner who financed the property to the new owner is going to be taking the property back. But that's not necessarily what occurs. That's just what typically occurs. What actually occurs is that the property is sold on the courthouse steps, and the creditor is able to enter what's called a credit bid. And in a credit bid, the creditor will bid the amount of money that is owed to the creditor at the sale. Now, and the creditor does not actually have to pay that money out of pocket, because those are funds that would be paid to the creditor if a third party had purchased the property. So typically the creditor is going to go ahead and credit bid the sale for the full amount owed to the creditor, and for a third party to buy the property at the sale, they would have to bid more than what's owed on the underlying note.
That's great information. So let me kind of recap. So in the state of Texas, if you have a purchase money loan, a loan given to for someone to buy a property with, then you can foreclose on that collateral if the borrower doesn't pay in a non-judicial foreclosure, which means you can sell their property on the courthouse steps. How does that work?
Yeah, real quick, I should probably mention that you do have to have a promissory note and a deed of trust in order to do that. Theoretically, you could owner finance a property with just a vendor's lien in the deed itself, and in that case, you'd have to foreclose judicially because the way that you can foreclose non-judicially in Texas is by appointing a trustee to sell the property on the creditor's behalf pursuant to the terms of a deed of trust that is securing the promissory note. And so if you don't do that, you're not going to be able to foreclose non-judicially. So I just thought I should mention that. But as long as you close your seller finance note at a respectable place that understands how to do seller finance, then you should have the correct paperwork.
Mm-hmm. And for the sake of stating the obvious, we want a non-judicial foreclosure because it's faster and it's cheaper. Is that correct?
It's much, much faster and much, much cheaper. You're looking at, 60 days after the acceleration process compared to potentially years in the court systems.
Yeah. And so that when I am looking at states to invest in as a mortgage investor, one of my criteria is I only want to do business in states that have non-judicial foreclosure as an option. In the very rare instance where I'll do a loan in a judicial foreclosure state, like Florida is a state that I do like lending in, and that's judicial foreclosure, but then I require significantly larger equity in the property. So I'm a little bit more conservative when I'm making loans in Florida than when I'm making loans in Texas, or purchasing loans in Texas, for example. So what's really cool about a deed of trust is that you mentioned the deed of trust assigns a trustee, and that trustee is the person who sells the property at the courthouse steps. So tell me, how do you identify a trustee in the deed of trust, and then what does that trustee do, and then who is the trustee? Are you the trustee of the foreclosure sale?
Yeah, I'm the trustee on a lot of deed of trust that we originate here at this office. My business associate, Derek, who's in the office next to me, will be the trustee. And then you, as the creditor, you can appoint a substitute trustee. So regardless of what name you put on your original loan documents, appointing a substitute trustee is very easy to do. And you don't even need the consent of the original trustee to do that. You only need the consent of the creditor. So at the time that you originate the loan, you're going to put somebody's name down as the original trustee under the deed of trust. And that name is very easy to find. It's going to be usually on the first page of the deed of trust. And that's the person who's been appointed to sell the property. You can even have multiple trustees. You can put 5 or 6 people as trustees under a deed of trust, and any one of them can sell the property without doing a substitute trustee's appointment. However, doing a substitute trustee's appointment is not difficult. It's not going to delay the foreclosure proceedings.
Mm-hmm. So what's best practice as a lender when I'm choosing a trustee's name to put on that deed of trust? Do I put my own name? Do I put my attorney's name on that document? Do I put the name of my company? What's best practice for choosing a trustee to put on that deed of trust?
That's a good question. I would not put your own name on there, only because you might get tied up in the wrongful foreclosure suit, and those allegations would be made against you personally or in your capacity as the trustee. And there's no reason to take on that liability when you could just close the transaction with a company that handles seller finance loan origination and can give you a name of somebody like myself to put down as the trustee.
Awesome.
And
So
I don't charge people money to be put as the trustee on the original loan documents because there's no actual responsibilities that occur until there's a default. And even if a default does occur, you can just appoint a different trustee. So
So if I'm watching this on YouTube and I've never actually talked with Ian Ghrist before, and I'm creating a note and deed of trust, can I put Ian Ghrist on that deed of trust, knowing that if it does go into default, I'll call your office and say, Ian, I chose you as the trustee. Now, even though we've never talked before, can you help me out now?
You should at least call the office and let me know that you're doing it so that I can put it in a file. So in case anybody calls me who's been looking at the public records, I'll at least have some idea what's going on. But yeah, that's not a problem.
Yeah, so it's very easy to identify a trustee. And I, in my personal experience, if I've named, let's say, my company as trustee, the challenge with that is my company isn't going to be the actual trustee. And so I'm going to have to go through the time and nominal expense of naming a substitute trustee. And so my best practice is I'll always name an attorney like Ian, who is in the business of doing foreclosures. I'll name them as my trustee, because on the possibility that this goes into default and I'll call Ian and say, Ian, I named you as trustee in this deed of trust, can you help me foreclose? Then I've already picked a suitable party to do the trustee. If I named my grandma as trustee and she's not an attorney, then I'm guaranteed to have to file that substitute trustee, which, you know, it's just a small cost and time that is unnecessary. But I do like that best practice that you said, don't name yourself, because that's a personal liability that's unnecessary. Yeah, so...
Yeah, it's probably not going to be a problem, but it's just something that you don't need to do. And also, if you want to stay anonymous, if you do all your business under an LLC, there's no reason to put your personal name on anything.
Yeah, awesome. So when you do close, you know, we're going to take a step back and go big picture. When you're putting your loan documents together, or your title company or your attorney is putting your loan documents together, that person who's writing the documents is going to choose a trustee, and then just best practice, just see whose name they put on there, right? And that they did name someone, right? It'd be, you know, poor form, but it's possible that they created a deed of trust and didn't name a trustee, and that's problematic. And then, so Ian, once somebody gets to a borrower who's not paid on their note long enough, and then what is that process? Like, how many payments do they have to miss? And then what's the process from the time the borrower stops paying on day one until the lender gets possession of the property? And at what point should their note servicing company stop working the file and your law firm start working the file? What's that timeline and process like?
What I typically tell people is that you shouldn't start the foreclosure process until the borrower is at least 2 payments behind. So, 60 days after the first default is a good time to start thinking about starting the foreclosure process. And the foreclosure process starts with a notice of intent to accelerate the note. And we talked a little bit about what acceleration is. You do need to give notice of intent to accelerate before you give notice of acceleration. It's very important to do that. There's a lot of case law on this, and the courts treat that notice of intent to accelerate, in my opinion, even more seriously than they do the notice of acceleration itself.
So to put that in layman's speak, you have to tell the borrower that they have the full balance, that you're intending on foreclosing, and then once you give them that intention, then you can give the actual notice that you are foreclosing.
There's a difference between the notice of foreclosure and the acceleration notices. You're going to do a notice of intent to accelerate, and then you're going to do a notice of acceleration probably 30 days later. Then you're going to do a notice of the foreclosure sale. So that's 3 notices. So you're talking about 30 days per notice, so that's 90 days, plus they've been delinquent for 60 days. So you're talking a total of 120 days. Am I doing the math right on that? That's 60 and 90 is 150 days.
So they missed, let's say January 1, the borrower has a payment that's due and they don't make it. And then they've got a grace period to say the 15th of the month. So the 15th of January comes, they haven't made their first payment. And then it's technically late, and the servicing company will call and say, hey borrower, you need to make your payment. Then February 1st comes and they don't make the payment, and then February 15th it's late again, and then now they're 2 payments behind. So February 15th, is that the date they should call your office?
Yeah, that would be great. You may want to wait till they're a full 60 days delinquent. And the reason is that under the Dodd-Frank Act, and this could potentially apply to anybody that's doing seller finance involving principal residence of the borrower, there's a 120-day cooling period between the day that the borrower first defaults and the day that you post the notice of foreclosure sale at the county courthouse. And if you wait until the borrower is 60 days behind, by the time you finish the acceleration process, you should be right at that 120-day mark where you're ready to go ahead and foreclose in a way that's compliant with the Dodd-Frank Act. Now, if you do only a few seller finance notes, you may not be, the Dodd-Frank Act may not apply to you, but that's a very complicated issue.
Mm-hmm. This whole foreclosure process is fundamentally very simple. If the borrower doesn't pay you, you hire an attorney. The attorney helps you get possession of the property. So fundamentally, it's very simple. But then the nuts and bolts, this hopefully the listeners and viewers at home are figuring out that the nuts and bolts are complicated, that you're absolutely going to hire a law firm to go through the foreclosure process for you. That fundamentally it's simple, but the actual implementation is something that you're going to hire a team to do. So maybe you could talk about the costs involved when a borrower doesn't pay. What does it typically cost? And I know those costs changes from firm to firm, and this is not a price quote that you're offering, but just industry-wide. What does it cost to foreclose on a uncontested foreclosure in Texas?
I think it probably ranges from $750 to $2,500. Anything more than that would be ridiculous, in my opinion, unless there's something extremely complicated or difficult. Obviously, if you're doing an expedited foreclosure, which is called a quasi-judicial foreclosure under Texas Civil Procedure 736, you're going to bill a lot more for that because it's a lot more work. And if you're doing a judicial foreclosure, obviously that's going to cost a lot more. But there's attorneys that would do a foreclosure for under $1,000, but they're probably talking about just the foreclosure itself, not anything more than that, including checking for IRS tax liens that need to be notified in order to wipe those out with the foreclosure sale, or doing the acceleration process.
Mm-hmm. So what are some of the most frequently asked questions that a new small creditor who's never gone through the foreclosure process, what are some of the questions that you might get that you think are most important for new small creditors to understand?
Oh, and one more thing I should mention on the fees is typically the foreclosure fees are going to be paid by the borrower, because the borrower is going to be responsible for paying the attorney's fees under the terms of the note and the deed of trust. So typically the investor is only going to pay those fees out of pocket if the foreclosure sale actually occurs. And if you underwrote your loan properly, then you should have enough equity in that property that you're going to be able to make a return on the property after you acquire it at the foreclosure sale. And so the fees really shouldn't be that big of an issue. Mm-hmm. But to address your question, a lot of people don't understand that the foreclosure is actually a public auction on the courthouse steps. And it's not a guarantee that the creditor will become the owner of that property. A lot of people want to know, well, how soon am I going to be the owner, and how soon is the tenant going to be evicted? And the answer is that you might not be the owner. Most of the properties that I foreclose on get purchased by the credit bid at the sale, but not all of the properties are going to be purchased that way. I've had people buy properties using cashier's checks at the time of the sale. And in that case, as the creditor, you're just going to be paid off in full. You're not going to become the owner of that property. And I've got clients who want that to happen, and I've got clients who don't want that to happen.
Yeah.
I've got clients who know how to sell real estate and they're happy to take the property back and resell it. I've got other clients who are terrified of having to do a rehab and they would much prefer to just be paid off.
Yeah, in my experience, is the more equity there is in the property, the more likely it is the lender's going to get cash. And the less equity there is in the property, obviously that means that the lenders, the credit bid, has kind of not overpaid, but they're the premium bidder, right? If it's a $100,000 property and the credit bid is $50,000, chances are someone's going to come bid 50,001 and get the property.
But you don't see as many of those, and probably because if the debtor is smart, they would just sell the property before the foreclosure. Because if they have equity, they should be able to do that. So, those are more rare, but they do happen.
Yeah, and usually it's a borrower who's obstinate or just not, has their head in the sand, like they're just trying to deny that the process is happening when that happens. So
that happens.
Yeah. Yeah. So frequently asked questions when you get a new client. What are some of the best questions you get?
Well, people ask about how the process works, when they should start. A lot of the questions that we've already covered. People will ask if they have a loan servicing company, how that works. There's different ways that you can handle that. I think the easiest way to handle it is to have the loan servicing company put the loan on hold while the loan is in the foreclosure process. And I would include the acceleration process as part of that. As soon as you send that notice of intent to accelerate the maturity of the note, at that point, I would have the loan servicing company or the creditor, if the creditor is servicing itself, stop accepting payments and direct all of the payments to the law office while the foreclosure is pending. And then if the borrower brings the arrearage current or meets the terms of any default cure offers that are made by the creditor, then the law office can return the funds to the loan servicing company or the creditor, and they can reinstate the loan. And what that does is cuts down significantly on miscommunications that can happen between the law office that's handling the foreclosure and the loan servicing company that's servicing the note. And you can also just have the borrower make payments either to the foreclosing law firm or to the loan servicing company or to the creditor, but then you get in a situation where you need to promptly inform your lawyer to stop sending notices and not to accelerate the note if you've already collected a payment. And sometimes I represent very small real estate investors who own or finance a couple properties, and they are not very organized, and they may not even inform me that they've collected a payment, and then my notices that go out could be wrong.
Yeah.
So this is just a way to cut down on mistakes. It's cleaner.
So best practice, have your notes professionally serviced, and once they are 2 payments behind, then you engage your firm to basically temporarily take over servicing until that note's either foreclosed or becomes performing again. Is that correct?
Yes, and what I'll do is return the file to the loan servicing company with a check for the full amount that the borrower's paid, less the attorney's fees that are due to the law firm. And then the loan servicing company can reinstate the loan and service the loan as if nothing happened. Oh, another thing that people bring up a lot is after acceleration, whether they should accept the arrearage or not. And a lot of people don't even understand acceleration, so they are perfectly happy to let the borrower reinstate the note by accepting the arrearage. And I think in most of the government-sponsored entity loan docs, like Fannie Mae and Freddie Mac, they have clauses in those loan docs that frequently obligate the creditor to accept the arrearage after acceleration and allow the borrower to reinstate the note, even though technically the note's been accelerated and the full remaining balance is due. But regardless of whether that's required by the deed of trust or not, you just need to tell your attorney who's foreclosing what terms you're willing to accept. And if you are willing to accept an arrearage in lieu of the acceleration, that can cut down on your chances of getting sued in a wrongful foreclosure suit or dealing with a bankruptcy filing on the day of the foreclosure. Or, sorry, my light's on an automatic timer, so if I don't move every once in a while, it shuts off. I just have to move, and then the motion sensor triggers the light. But yeah, that can cut down on bankruptcy filings, wrongful foreclosure lawsuits, and other things that are a big headache for note holders.
Yeah, that makes a lot of sense. So the attorney's costs are paid for by the borrower if the borrower brings the note current, and then they're paid for from the proceeds of the sale of the property if it goes all the way to foreclosure auction. And I think this is an important part of the quote unquote transfer of servicing temporarily from the professional servicer to the law firm, because it is very possible that the law firm is accruing expenses in the foreclosure that the servicing company is not aware of. And so when the borrower orders a payoff, maybe they're selling the home or refinancing the home, or they're bringing their loan current, oftentimes if the servicing company and attorney are not closely communicating, they can issue the wrong payoff demand, absent your total fees. But if you're the law office who's doing a temporary servicing of that default note, then you're certainly going to include all of your own fees and costs in that payoff demand.
You would think so.
So at least I think that's a really good best practice. So a lot of places where our clients feel lost is in that gray zone of who's doing what, because their note is professionally serviced, and then it goes on and on and on into late payment land, and they think that servicer is going to do something, that the servicer is going to magically initiate the foreclosure, or the servicer is going to hire an attorney or whatever. And in my experience, that isn't the case, right? That the borrower...
servicing companies don't automatically do that. You need to tell them to do it.
Yeah. So that's a really important thing. So this is a very hassle-free process as long as the borrower pays. But once they get, and you said 60 days, full 60 days behind, that's when the investor should start paying attention and then engage an attorney in the process. Is that correct?
Yeah, and that's just a rule of thumb. If you've got a borrower that's been delinquent over and over again, you may want to shorten that time frame a bit, or you may want to lengthen it if the borrower's been paying for 10 years without any problems and you're sure they're going to get caught up. But that's just a rule of thumb that I tell people. And it's a rule of thumb that helps you stay compliant with the Dodd-Frank Act as well.
Mm-hmm. My views on how quickly to initiate an attorney is also based on amount of equity in the property. If there's a very small amount of equity in my loan position, meaning maybe I have a $90,000 loan on a $100,000 property, that's not a lot of equity. And so if that borrower gets behind, I need to foreclose as quickly as possible, because their arrearage and legal fees are going to eat up my equity really quick. If I've got a very low loan-to-value loan, let's say a $70,000 loan on a $100,000 property, I might give that borrower a little bit more leeway, because I know I'm going to get paid regardless. And so once it goes into default, I'm getting my default rate of interest, I'm getting late fees, and I really do want that borrower to succeed ultimately. And if they bring their loan current and I get my late fees and my default rate of interest, that's a good thing, right? And if they don't succeed, I'm going to get foreclosed. I'm going to foreclose on the property, and then I'll get paid anyway.
Yeah, and that equity cushion is huge, because even in Texas, we've got non-judicial foreclosure, and the foreclosure can go quickly, but federal bankruptcy laws apply in every state, and you can have a borrower file bankruptcy, and then his spouse files a bankruptcy, and then they file a joint bankruptcy, and there's all kinds of delays that they can cause if they want to.
This is a really good segue because I think one of your unique selling propositions as a law firm is that you're admitted to practice law in bankruptcy court. And so oftentimes when you're hiring an attorney to do a foreclosure for you, if the borrower files bankruptcy, now you've got a bankruptcy attorney and you have a foreclosure attorney, and they have to integrate, right? And there's a communication thread, and there's potentially redundant billing in that process. Versus if you retain your law firm, you can coordinate the foreclosure and the response to the bankruptcy all in one place at one central point of contact. Can you talk about that unique selling proposition and why it's important to hire a firm like yours that can coordinate both processes?
Yeah, I would say that most law firms either handle foreclosures or bankruptcies, but generally not both. It probably depends on the law firm somewhat, but I tend to represent smaller clients, and it's just much easier for them to have a one-stop shop for the foreclosure and the bankruptcy. There's probably something to be said for hiring a lawyer who only practices in bankruptcy court and who the judge knows extremely well. But when you're dealing with lift stays and things like that, those are very routine. Actually, most of the things that happen in bankruptcy involving secured creditors on residential property are fairly routine, although the paperwork can be very complicated, even for a state court litigator, if they're not familiar with it. So I don't think it's probably necessary on an owner finance case involving one property to get a law firm that specializes in bankruptcy law. They're probably going to bill you an exorbitant amount compared to the issues that are really at stake and how routine the process is. But there's also a lot of state court litigators that will do foreclosures on the side, and they may not have any idea how to practice in bankruptcy court. Mm-hmm. So I do both. I've been doing both for a while, and it's just what I do.
Yeah. So let's talk about the potential, the simplicity of the foreclosure process, how it gets slightly more complicated if the borrower files for bankruptcy protection. And so to try to put it in layman's terms, because I'm not a lawyer, so as a creditor, holding the paper, the borrower doesn't pay, I filed for foreclosure, and the borrower says, hey, I've got equity to protect in my property, I don't want to be foreclosed upon, and I want to probably stay in my home also, because I don't want to lose my equity, and I think I can keep making my payments if I just get a little breathing room. So then they hire a bankruptcy attorney, and they tell that bankruptcy attorney, I just need some breathing room on my payments. Can you stop this nasty lender from foreclosing on my property so that I get a chance to figure out what to do, right? So then that bankruptcy attorney, he's going to stall the foreclosure process, right? Enter Ian, right? So I say, Ian, I filed for foreclosure. The borrower wants to slow that process down so they can either live in the property longer or figure out a plan for selling their home and getting that equity, etc. How enter Ian in the process? What do you do on both sides? Let's say you're representing the borrower and you want to slow that process down, and then if you're representing the lender and you want to speed that process up.
Well, bankruptcy is a very complicated process, and we could probably do an entire video series on just bankruptcy law. But in general, the borrower on a secured debt is going to need to make all of the post-petition payments that come due. So any payments that come due while the borrower is in bankruptcy, the borrower is going to need to make those payments. There's some exceptions, like if you have a second lien and there's not enough equity in the property to cover the second lien, then the borrower may try to do what's called a strip off of that lien and have that lien basically treated as unsecured debt in the bankruptcy because the collateral is not worth enough for the second lien holder to be paid in the bankruptcy. But assuming that you're not dealing with a weird situation like that, then the borrower is going to need to make all the post-petition payments but the arrearage that came due between the time that the borrower first defaulted and the day that the bankruptcy petition was filed, the borrower is going to be allowed in a Chapter 13 wage earner plan to pay that arrearage out over the course of 3 to 5 years as part of their payments, either direct to the creditor or more typically through the bankruptcy trustee's office.
So the
and if the borrower doesn't do either of those things that the borrower is supposed to do, at that point you may need to hire an attorney to file what's called a lift stay motion, which when a bankruptcy petition is filed, an automatic stay of all collections activities goes into effect. And you can be held in contempt of court if you fail to comply with that automatic stay of collections activities, because the automatic stay carries the weight of an order of a federal bankruptcy court. And so when you hire a lawyer to file a motion to lift the stay, what you're doing is asking the court for relief from the automatic stay, typically on the grounds that the borrower failed to provide adequate protection for the loan. Because as a secured creditor, unlike an unsecured creditor, you have a property interest in the collateral that is securing your loan. And because you have that property interest, the borrower is going to need to pay your loan in full, even if the borrower is planning on paying the unsecured creditors pennies on the dollar.
That was huge. I hope everyone listening got that. That when you're a secured creditor, meaning you have a recorded lien against the property, then you get paid first 100 cents on the dollar before someone like a credit card payment or a medical bill would get paid in pennies on the dollar. So even in a foreclosure or bankruptcy process, the secured creditor gets paid everything first, and then the leftovers go to the unsecured creditors. Is that your understanding?
Right, that's correct.
Mm-hmm. And so the stay of foreclosure is the court saying, "Hey, lender, don't foreclose because we think the equity in that property could be used to satisfy some of the other creditors. And if you, as the secured creditor, foreclose first, it's not really fair to the other people waiting in line, right? So they're going to slow that process down to allow that borrower either to come up with a payment plan or to activate that equity through sale to satisfy other creditors. But as a lender, I don't necessarily want to wait for the borrower to figure that out. I want to speed the process up so I can get my cash back from that deal. So that's when the lender's attorney files, you call it a relief of stay, which allows you to proceed with the foreclosure because you think that the foreclosure is in the best interest of the lender. And what do you need to get that relief of stay approved by the bankruptcy court?
Yeah, it's not that you're filing a motion for relief from stay because the lender wants the relief. I mean, obviously the lender wants the relief, but what you have to show to the court in order to have that relief granted is that the property interest that the lender has in that property as collateral for the lender's secured debt is not being adequately protected by the borrower. And you can show the most typical way to show that the property is not being adequately protected by the borrower is that the borrower fails to make the post-petition payments that are due to the creditor. But there could be other reasons. Like if the borrower fails to keep insurance on the property, then the property is not being adequately maintained. If the borrower fails to pay the property taxes, again, the property is not adequately being maintained. And if the borrower is far enough behind on the note, the borrower might not have enough money in the borrower's escrow account to pay the taxes. And in that case, the lender is going to have to step in and pay the taxes, potentially, to avoid the taxing authorities foreclosing on the property. So there's other reasons that the property would not be adequately protected, that it's not the property, but the security interest would not be adequately protected. And what you're doing from the lender's standpoint is filing a motion with the court and showing the court evidence that the borrower is not adequately protecting the creditor's collateral. And if the collateral is not being adequately protected, the court should grant the creditor's request for relief from stay, at which point the bankruptcy would no longer apply to the creditor's interest in that collateral, and the creditor could proceed to foreclose under state law. If the bankruptcy court found that the debtor was adequately protecting the collateral, then the bankruptcy court would deny the motion for relief from stay, and the debtor would be able to continue to make payments through the Chapter 13 plan.
Awesome. Ian, you've been very generous with your time today and a wealth of knowledge. And if somebody is looking for help and they need an attorney, again, I'd highly recommend that our viewers out there call Ian. He's been fantastic to work with, and he's my go-to person when I do need legal assistance in getting my non-performing borrowers to become performing borrowers. What's the best way, I know you mentioned this earlier in the video, but we're going to say it again, what's the best way for someone to engage you, and are you open to questions if someone has a specific situation that they have a question about?
Yeah, you can contact me through the website. You can contact me at 817-778-4136. That's the office number. Sometimes we do free consultations, but most of the time we charge a consultation fee for new legal matters of $50 to $100, depending on how long of a consultation you need and how many documents you're planning on bringing to the meeting. You can call that number and you'll get either myself or Daisy Gomez-Reyes or Basil, my paralegal, and they can all make appointments in my calendar if you need to talk to me. And we're happy to take calls, and you can also contact us through the website.
Awesome. If you're listening to this video and you're looking for investments in secured mortgages, particularly seller finance notes in the state of Texas, I'd be very happy to talk with you about how you can engage in that type of investment activity. You can learn more on my website at hasslefreecashflowinvesting.com, or you can email me, David, at hasslefreecashflowinvesting.com, and we can help you figure out how to get your cash or IRA invested into performing mortgage paper that hopefully stays performing. But if it doesn't perform, always know that it's a very simple process. The borrower pays or they don't pay. And if they don't pay, which is very unlikely, the vast majority of mortgage paper does pay. But in the unlikely event that they don't pay, you know that you've got someone like Ian on your team to make that process as hassle-free as possible to protect your investing dollars. Thank you everyone for your time today, and especially thank you to Ian for taking the time to help record this video for all of our mutual benefit. And look forward to talking with you all in video land.